I have a question for both Attorney General Horne and Richard Martinez, and it is a suggestion that's been floating around in the last few weeks, and the question is a compromise, an acceptable compromise position, making American history the foundational course in a school like Tucson High with ethnic studies classes being offered as an elective? Would that be something that you would find acceptable?
In the findings that I issued, I focused on the fact that I believe it's unconstitutional to divide students by race. That's the key to me. So from my standpoint, minor adjustments in the curriculum don't solve the problem. Now, it's not my decision to make. John Huppenthal is the superintendent, and it'll be his decision to make. And our decisions, by the way, are not unilateral the way my friend here described them, as though one person makes all the decisions. It's subject to an appeal to an administrative hearing officer and subject to process. It's not a one-person decision. But the fundamental issue to me is the issue of dividing students by race. I believe, I'll confess to this, I think there was an implied criticism. I believe in the colorblind society. I believe in the colorblind society, and I believe it is an integral part of our Constitution. Not the Constitution that was originally written that had references to slavery and so on, but the 14th Amendment, which tells us we cannot discriminate on the basis of race, religion, and so on. The 14th Amendment is a part of our Constitution, and the 14th Amendment tells us, as John Kennedy said, race plays no proper part in American life or law, and American public schools have no darn business dividing students by race. That's the fundamental issue. That's the issue that relates to the very first legal principle that we agreed to, which is that educational decisions based on race are unconstitutional. It is unconstitutional, in my opinion, to divide students by race in the American public schools in the 21st century.
Richard, do you have a stand on whether making the ethnic studies an elective is a compromise that would be acceptable?
Taking Mexican American Studies and turning it into elective, I think, is a fatal blow. It ends the program. And it ends the program in many ways, and I also think it has a discriminatory impact with a discriminatory intent behind it. Why should those students who want to take Mexican American Studies not have that class count towards graduation with respect to their English credit? Why should it not count towards their history credit in their junior year? Why should it not count towards their government credit in their senior year? Why is it that if we are going to take, any student is going to take Mexican American Studies classes, they have to do it as something extra as opposed to being a graduation credit? That is treating students differently and treating the curriculum differently. And I believe that it is the same kind of message that creates a second-class status. A second-class status that is unacceptable and been rejected by women, that is rejected by people of color, and by anyone who's been relegated into that role. So no, I don't accept that. The notion that keeps coming back to that we divide by race. If we divide by race, it is only because students choose to continue to attend a public school that is segregated because it's the only school available to them. And then they make a choice to come into, on their own or with their parents' involvement, into the Mexican American Studies class. We don't direct them. We don't force them. And that you get a higher percentage of students who are Latino in a Mexican American Studies history class or American history from the Mexican American perspective, I don't think that's surprisingly something phenomenal. Is that an act, a de jure act of discrimination, an intentional act of discrimination? Of course not. And Mr. Horne knows that the Supreme Court long ago rejected de facto segregation. If we were into de facto segregation and correcting de facto segregation, we wouldn't have the housing patterns we have in this country. If we were into enforcing as unlawful de facto segregation in schools, we wouldn't have the segregated schools we have today, because then Milliken wouldn't have been decided the way it was, and Detroit would have been desegregated, and it wasn't. So, you know, you play fast and loose with constitutional concepts that our Supreme Court has rejected because they went to a certain line and then backed off. That's the reality. We went and like to say we're about integration, but we're really not, because we're not yet comfortable with it. It's like many other debates in this country. We like to talk about, we want to integrate other groups. We want to accept a new definition of marriage, but we really don't. You know, and it is only when we make those fundamental changes in our country, which we will, but sometimes we get tired and impatient with waiting and waiting and waiting for that change.
I'll give you a chance.
Okay.